Welcome to Chapter 10 of Medical Law and Ethics, Workplace Legalities. Throughout this chapter, we will cover the following learning outcomes. We'll identify federal laws regarding hiring and firing, discrimination, and other workplace regulations, describe the Occupational Safety and Health Administration's, OSHA's, top workplace priorities. We'll examine the role of healthcare practitioners in following OSHA, Centers for Disease Control and Prevention, or the CDC, and Clinical Laboratory Improvement Act, CLIA, standards for workplace safety. We will also summarize the purpose of workers' compensation laws and unemployment insurance, and determine the appropriate legal process for hiring employees and maintaining the required paperwork while the person is employed. Here's a list of key terms that we will cover in this chapter. Employment at will. This was the original concept of employment whereby the employer or the employee can end employment at any time for any reason. This meant that employees could be refused employment and could be disciplined and fired for no reason. Now, employment at will is affected by both federal and state statutes, executive orders, case law, contracts between workers and employers, collective bargaining agreements between companies and unions, and civil service rules for government workers. Hiring and firing. So employees generally cannot sue their employers simply because they've been fired. But employers cannot fire an employee for illegal reasons. When no law exists that prohibits a specific reason or there's no basis for firing them, the discharged worker may have cause for a wrongful discharge case. So an employer risks litigation or if he or she does not have just cause or legal reason for firing an employee. The employer must have documentation that shows just cause. This is paper trail, documents, video, something that would prove the reasons behind firing this employee. An employer is more likely to lose a wrongful discharge case if they've terminated the employee for something that violates public policy. Public policy is a common law concept of wrongful discharge when an employee has acted for the common good. So these common good reasons are things like refusing to commit an illegal act during their employment, whistleblowing or tattling on wrongful acts of their employer, performing a legal duty, or exercising a private right while at work. These are usually pretty easy to prove. They also prevent companies from retaliation suits for whistleblowers. Currently, federal laws forbid discrimination in any aspect of employment. These things include hiring, firing, pay, job assignments, promotions, layoffs, training, fringe benefits, or any other term or condition of employment for any of the following reasons: being of a particular race, color, religion, or national origin, or being male, female, or transgender, being over 40 years of age, having a history of a disability or having a disability that may be accommodated, having a particular genetic disposition, being pregnant, or joining a union or engaging in political activity. Title VII of the Civil Rights Act has made sexual discrimination illegal as well, and sexual harassment is considered a form of sexual discrimination. So the Equal Employment Opportunity Commission, or the EEOC, identifies sexual harassment as follows: unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitute sexual harassment when submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment, or submission to or rejection of such conduct by an individual is used as a basis for employment decisions affecting said individual, or such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. The first two portions of this are known as quid pro quo sexual harassment, or from the Latin meaning something for something. Your condition of employment is based on your acceptance of something or your willingness to do something. Part 3 prohibits conduct that interferes with an employee's work performance or creates a hostile working environment. So Part 3 does not even have to be that you yourself are being sexually harassed. It could be somebody else near you that affects your work environment. You can have, as such, secondhand sexual harassment and still have it be a viable discrimination. Employers can be found guilty of sexual harassment, A, if they are a supervisor over a lower employee and are sexually harassing them, or B, if they know of the sexual harassment but have done nothing to stop it. In both of those cases, the employer and the supervising party can be held responsible for sexual harassment. Federal labor and employment laws. We'll start with discrimination laws, and there's a fairly lengthy list. We'll begin with the Wagner Act of 1935, and this act made it illegal to discriminate in hiring or firing because of union membership or organizational activities. Then we'll move into the Civil Rights Act of 1964, Title VII, which was affirmative action. And this act applied to businesses with 15 or more employees working at least 20 weeks of the year. The law prevents employers from discriminating in hiring or firing on the basis of race, color, religion, sex, or national origin. Some states also have laws that prohibit discrimination based on marital status, parenthood, mental health, cognitive impairment, sexual orientation, personal appearance, or political affiliation. Title VII also specifically prevents federal judges from using affirmative action plans. These are programs intended to remedy the effects of past discrimination. They're not allowed to use these to correct imbalances inside of work populations. They are only allowed to use them in corrective instances where discrimination against a specific minority group has been proven. Title VII also created the U.S. Equal Employment Opportunity Commission, or the EEOC, and they enforce Title VII provisions. They also brought the Age Discrimination in Employment Act, the Equal Pay Act, and the Rehabilitation Act. Moving on to the Age Discrimination Act of 1967. This act also applies to businesses with 20 or more employees working at least 20 weeks of the year, and it prohibits discrimination in hiring or firing for people over the age of 40. The Older Workers Benefit Protection Act of 1990 is also a federal age discrimination law. The federal version prohibits employers from denying employee benefits to older workers based on age, trying to keep their health benefits cheaper by denying those benefits to older employees. The Equal Employment Opportunity Commission, or the EEOC, enforces both of these acts. So the Rehabilitation Act of 1973, this act applies to employers with federal contracts of at least $2,500. It prohibits discrimination based on physical abilities or mental health. It also requires federal contractors to implement affirmative action plans in hiring or promoting employees with disabilities. The 1976 Pregnancy Discrimination Act. So this probably sounds crazy, but it's an amendment to the Title VII of the Civil Rights Act that makes it illegal to fire an employee based on the fact that they are pregnant, have had a child, or related medical conditions from the pregnancy. The Americans with Disabilities Act of 1990. This one also affects employers of 15 or more employees working at least 20 weeks during the year. So it bans discrimination against persons with disabilities in the workplace. In September of 2009, the American with Disability Act amendments, or ADAA, were passed by Congress. This broadened the definition of a disability and struck a balance between employer and employee interests. They also mandate equal access for workers who are disabled to certain public facilities and require all commercial locations or businesses to make their facilities and grounds more accessible to people with disabilities. The Civil Rights Acts of 1991, two new important benefits for employees who can prove discrimination. They're allowed to collect punitive damages, and the employees may collect damages for emotional distress associated with these incidents of discrimination. So the Genetics Information Non-Discrimination Act of 2008, or GINA. So with the advances of healthcare and genetic testing, we can have predetermined risk factors for certain genetic types. And this act prohibits discrimination in health insurance and employment based on this genetic information. It doesn't allow you to use information we've gained on how to treat you against you in the workforce. And then lastly, the Lilly Ledbetter Fair Pay Act of 2009. So this law was a response to a court case where Lilly Ledbetter was underpaid by 20% compared to her male counterparts. This went on for years and years. And when she took it to court, they said that she was no longer within the statute of limitations. So largely this act revised previous employment acts and extended the statutes of limitation trigger dates and opened up a larger class of plaintiffs. This way, if you were affected by unlawful discrimination and wanted to recover back pay, it extended the time period to file those cases. Wage and hour laws. The 1935 Social Security Act. This was funded by the Federal Insurance Contribution Act, or FICA. It now also encompasses the Old Age and Survivors Insurance, which is OASI, O-A-S-I, and then the Public Disability Insurance, Unemployment Insurance, and hospital insurance through Medicare. All of these were incorporated into the Social Security Act. The Fair Labor Standard Act of '38. This act prohibits child labor and the firing of employees for exercising their rights under the Act's wage and hour standards. It also guarantees overtime pay and a minimum wage. The Equal Pay Act of 1963 is an amendment to the Fair Labor Standards Act and requires equal pay for men and women doing equal work. And lastly, the Employee Retirement Income Security Act of '74, and this one regulates private pension funds and employer benefit programs. Part of its provisions, employers cannot prevent employees from collecting retirement benefits from plans covered in the Act. So moving on to workplace safety laws, they established the Occupational Safety and Health Act of 1970. This is OSHA. This act ensures the safety of workers and prohibits firing an employee for reporting workplace safety hazards or violations. We'll talk more about this in just a moment. Another term of employment is the FMLA, or Family Medical Leave Act. So this act is for employers with more than 50 employees, and it allows employees to take unpaid leave time for maternity, adoption, or caring for ill family members. It's not that you get money while you are not at work, but it guarantees that your job will still be there when you return. So in 1970, Congress passed the Occupational Safety and Health Act. This was in response to the frequency of job-related disabilities and injuries in the 1960s. The act created or established the Occupational Safety and Health Administration, or OSHA. So OSHA has been charged with writing and enforcing compulsory standards for health and safety in the workplace. They're there to speak up for the employees, to create safe work environments. The Act covers employers and employees with very few exceptions, and their standards cover 4 general areas of employment. These would be general industry, maritime, construction, and agriculture. They have regulations for everything, but they include the physical workplace, machinery, equipment, materials, power sources, processing, protective clothing, first aid, workplace administration. These standards also make sure there's proper record keeping, and they cover whistleblower protection. So if you report your employer, they protect you from retaliation. So because they can't be everywhere at the same time enforcing these standards for every business, they have a priority of workplace inspection list. So their first in their list is imminent danger situations. So this is any condition where there is reasonable certainty that a danger exists that could cause death or serious physical harm at any moment. So if they find an imminent danger situation, they ask the employer to voluntarily remedy the situation so employees are no longer exposed to this. And if the employer fails to do this in a very timely manner, the OSHA officer can actually stop work. They can shut down the company until that situation is resolved. Their second priority is severe injuries and illnesses. So this is fatalities, accidents resulting in death or hospitalization of 3 or more employees inside of a short time frame. Employers must report all workplace-related fatalities within 8 hours, all workplace and inpatient hospitalizations, amputations, or losses of an eye within 24 hours. So they are looking out to stop repeat offenses. Their third priority is formal employee complaints. So if they have reports of workplace hazards or safety violations from employees, they go out to check out the site, and they try to protect the anonymity of the employee. They also have whistleblower regulations just to make sure that there isn't retaliation against them for making the complaint of safety. They do targeted or programmed inspections aimed at specific high hazard industries or individual workplaces that have high rates of injuries or illnesses. So if you're in an industry or a business that has high likelihood and high past history of injuries, they're going to do more inspections on your locations. And then lastly, they have follow-up inspections to make sure that violations cited in previous inspections have been remedied, have been solved in some manner to prevent reoccurrences. So under OSHA standards, both employers and employees have certain rights and responsibilities. Employers must provide a hazard-free workplace and comply with all applicable OSHA standards. They must inform their employees about safety and health requirements. They have to keep certain records and compile and post annual summaries of work-related injuries or illnesses. So in order to help with this, the employers must ensure that employees are wearing their safety equipment when necessary and provide safety training to new employees and discipline employees for violation of safety rules. The law does prohibit employers from retaliating any way against employees who file complaints under the Act. Employees also have responsibilities under the Act, and for these they must comply with the applicable OSHA standards, report hazardous conditions, follow the safety and health rules put in by the employer, and use protective equipment when necessary. Many states have right to know laws. These are laws that allow employees access to information about toxic or hazardous substances. The employer duties, employee rights, and other workplace health and safety issues. The Occupational Exposure to Bloodborne Pathogens Standard is an OSHA regulation passed in 1991. This standard is designed to protect healthcare workers from exposure to bloodborne pathogens such as HIV, hepatitis B virus, and hepatitis C virus. The Needle Stick Safety and Prevention Act, passed by Congress in 2000, modified the Occupational Exposure to Bloodborne Pathogen standards and included new provisions requiring employers to maintain Sharps injury logs and to involve non-managerial employees in selecting safer medical devices. This means the people picking out the devices are the same people who are using the devices. They also had CDC guidelines for universal precautions started. Some of these are things like do not contaminate the outsides of containers when collecting specimens. Wear gloves while handling specimens, masks or goggles if they're needed. Do not pipette by mouth. Use mechanical pipettes. Use extreme caution when handling needles, and do not bend, recap, or remove needles from disposable syringes. Decontaminate work surfaces. This is after a spill of bodily fluids or at the end of each workday. Never eat, drink, smoke, or apply cosmetics inside the laboratory. Remove protective clothing and wash your hands before leaving the laboratory. And clearly mark stored specimens as hazardous. Some other OSHA health standards are the Hazard Communication Standard. This is an OSHA standard intended to increase healthcare practitioners' awareness of risks, improve work practices, and appropriate use of personal protective equipment, and reduce injuries and illnesses in the workplace. One of the main components of the Hazard Communication Standard was to have written hazard communications or material safety data sheets or safety data sheets. That is a newer acronym for them. This was information based on the chemical makeup and prevention of accidents, also cleanup in case of accidental spills that are incorporated into each hazardous material. Employers have to have these available to employees, and companies producing these chemicals have to send them with new chemicals. The Hazard Communication Standard is now aligned with the United Nations Globally Harmonized System of Classification and Labeling of Chemicals, or GHS. It's a very short acronym for a very long name. The GHS established very common phrases, things like fatal if swallowed, toxic if swallowed, harmful if swallowed, may be harmful if swallowed. It took out the gray area of toxicity to make sure people had an adequate understanding. They also came up with pictograms to represent most of the different types of irritants that chemicals are. The General Duty Clause of the Hazard Communication Standard states that any equipment that may pose a health risk is included as a hazard. This covers all areas for which OSHA has not developed specific standards and holds the employer ultimately responsible for the safety of their employees. The Chemical Hygiene Plan is a standard for occupational exposure to hazardous chemicals in laboratories. This is to protect workers from harm due to hazardous chemicals or materials, and it's a written program that includes the policies, procedures, and responsibilities designed to protect workers from these hazards inside of their workplace. Okay, moving on to the ionizing radiation standard. This applies to medical and dental offices, also x-ray machines, and they need to maintain and survey all the types of radiation used, set aside specific areas for which employees can limit their exposure, and provide all personnel dealing with radiation pocket dosimeters or film badges to make sure they're not getting too much radiation exposure. They also require caution signs to label the rooms and equipment where exposure could occur. So an exit route standard. This requires safe, accessible building exits in case of fire or emergencies. They must have exit route maps, etc. for the employees, making sure they know the safest and quickest way out of the building. The electrical standards, OSHA's electrical standards apply to specialized electrical equipment and wiring in hazardous locations, and special wiring and equipment if the facility also uses flammable gases. This is just holding them to a higher standard in these high-risk locations. The Medical Waste Tracking Act has given OSHA the rights to inspect hazardous medical waste, and they can cite facilities for violations. Things included in this is having sharps contained in puncture-proof containers, making sure medical wastes like blood products, body fluids, tissues, cultures, vaccines, gloves, speculums, cotton swabs, all these things are put into puncture-proof, leak-proof containers. Chemicals need to be discarded in glass or metal containers, making sure that they're getting rid of hazardous materials in the right way. The CDC also has some general guidelines for laboratory use. They want you to wear gloves, eye masks, gowns, or other protective equipment when performing tasks such as capillary puncture, phlebotomy, pelvic exams, minor suturing, and throat cultures. They also would like you to wear protective equipment when performing tasks that do not involve direct contact with blood, body fluids, or tissue in case an accidental exposure occurs. These tasks include urinalysis, blood testing, examination of fecal occult blood, injections, positioning for x-rays, or doing ultrasounds or ECGs, and examination of sweat, tears, and nasal secretions. So the Clinical Laboratory Improvement Act, or CLIA, was a federal statute passed in 1988, and it established minimum quality standards for all laboratory testing. It also defined laboratories as any facility that performs laboratory testings on specimens derived for humans for diagnostic purposes, treating disease, or assessing health. They require that laboratories obtain certification. This is every 2 years typically, pay applicable fees, and follow regulations concerning testing, personnel, inspections, test management, quality control, and quality assurance. So they want you running QC or quality control on your equipment daily to make sure that you are generating accurate results. Moving on to workers' compensation. Workers' compensation is a form of insurance established by federal and state statutes that provides reimbursement for workers who are injured on the job. So in order to qualify for workers' comp or workers' compensation, you would have to be injured while you're at work and on the work site, whether that's at a facility or an off-site location. Workers' compensation would give you benefits for medical treatment, temporary disability indemnity, so you'll get cash payments for a temporary basis if you're disabled temporarily, permanent disability indemnity, which is cash payments for a permanent disability. Those usually are forever. Sometimes they can be a lump sum, sometimes they're weekly or monthly payments. It also covers death benefits to survivors. So if you had a family member who was killed at work, you could get benefits to help sustain your family in their loss. And then it also covers rehabilitation benefits, which can pay for either medical or vocational rehabilitation. So something to help you get back to health or train you for a new job. In order to qualify for workers' compensation, the injury must be reported to a supervisor immediately, and then an injury report must be filled out, and the doctor that sees you for your injury must also fill out paperwork and file it with the appropriate agency. When a claim is filed, all questions must be answered in full and as thoroughly as possible. Unemployment insurance funds are managed jointly by state and federal governments. Employers contribute to a fund that is paid out to eligible unemployed workers. So usually when you're working, your employer is paying into this fund. If you become unemployed and you need to file a claim, the required information to file a claim is a Social Security card, your W-2 statements for the past 1 to 2 years, your wage records for the last 18 months, employers' names and addresses for the past 18-month employment period, a statement of the reason for leaving your previous job, and your employer's unemployment insurance account number if you have it available. Due to federal and state laws against discrimination in hiring, interviews and the questions available to be asked have changed dramatically. So you cannot ask any questions regarding the applicant's race or color, religion or creed, gender, family, marital status, method of birth control, age, birth date or birthplace, if they're disabled, if they have a arrest record, how long they have lived somewhere, and or their national origin. The only exclusion to this is the I-9 form from immigration to make sure that you are a legal citizen and or legal to work in the United States. You can't ask if they were in the military, if they have military experience, or the status of their discharge, or membership in any organization or clubs. Some general guidelines to successful interviews without crossing into any of those questions that are unavailable to you is to make a list of questions pertinent to the job description and stick to them. Don't rush through the interview or allow it to drag on unreasonably. When you have a really long interview, you tend to stray into topics that are no longer accessible to you. You want to remain objective and listen well. Try to end the interview on a positive note. And you want to inform the candidate of decision, either when you're going to make the decision or how long it will be. A surety bond. So at some healthcare facilities, employees may collect fees or payments and handle financial matters. So employees can be asked if they're bondable. This would allow the employer to buy a type of insurance that allows employers to collect up to the specified amount of the bond if an employee embezzles or otherwise absconds with the business funds. So if you were to steal the funds from the office, they would be able to file with an insurance company to recover that money. However, the employer must have filed a complaint against this employee in order to collect on the bond. If the insurance company ends up paying out on a bond, they will try to recover it from the offending employee. So it's kind of like a bail bond for jail. They're going to try to collect that money back from you. Background checks are becoming more and more familiar and common in hiring practices. All of you actually had to do a background check for this course that you are taking. And for businesses, they can actually do a financial and criminal background check prior to your employment. And the prospective or current employee must acknowledge and sign off that the check is about to occur. Typically, if you refuse to get a background check, your chances of getting hiring are pretty low. So the official definition of a background check is the process of reviewing criminal and/or financial history to confirm information about an applicant before employment. Employment paperwork. So after being hired, your employee records must include the following. They have to have a valid social security number, the number of exemptions claimed for your tax records, so how many children, dependents, etc. you're going to claim. They need to have your gross salary, an I-9 or immigration form, your deductions for Social Security, Medicare, federal, state, and city taxes, and any other withholdings as far as insurance, disability, unemployment, health plans, any other withholdings that you have elected to partake in. At the end of every year, your employer will have to provide you with a W-2. This is a tax record given your wages for the previous year. And it must contain the following information. It needs to have the employer's tax identification number, the employee's social security number, the total taxable earnings paid by the employer. This usually will include other things such as non-taxed money or gifts or tips, etc. It will also include the amounts deducted for income tax and Social Security, and the amount of advance earned income credit payments, if any were made. Thank you for joining me for Chapter 10 of Medical Law and Ethics, Workplace Legalities.